Happy to reply.
The Honourable Adam Searle.
Mr Deputy President, I lead for the opposition on the Child Protection Working with Children and Other Child Protection Legislation Amendment Bill 2016. The opposition does not oppose the bill. The opposition will always ensure it does what it can to support any strengthening of legislation that guarantees child protection is front and centre of all of our considerations. Protecting children is or should be paramount for those of us charged with the public duties that we have. The bill seeks to amend the Child Protection Working with Children Act 2012, the Children and Young Persons Care and Protection Act 1996, the Teaching Service Act 1980 and the Education, School Administrative and Support Staff Act 1987. The bill seeks to implement various amendments concerning the governance of the Working with Children's Clearance Framework. As the opposition has already indicated in the other place, the Labor opposition is supportive of toughening the legislative framework governing child protection in New South Wales. Doing so remains a top priority for those of us on this side of the chamber, and we want to see every loophole closed without question to ensure that working with children checks continue to function as an effective safeguard to prevent unsuitable individuals from obtaining paid or unpaid work relating to children. The safety of children must always remain above partisan politics. Parliament has an overriding obligation to ensure legislation is passed that ensures child protection framework remains as fit for purpose as possible to keep children safe from harm. As the Minister indicated in his second reading speech, and the Parliamentary Secretary in this place indicated in her second reading speech, the Child Protection Working with Children Act was most recently amended last year in 2015. During the relevant Shadow Minister's contribution in the second reading debate on that bill, the opposition flagged concerns about a number of reported cases in which individuals who had committed serious offences had been able to appeal the decisions of the Office of Children's Guardian to continue working with children. We note that following a concerted campaign by the opposition, the Minister took on board those concerns. And those concerns were subsequently incorporated into the bill. The common sense amendments that the Shadow Minister had drafted and provided to the Minister were incorporated in the government's thinking, and those amendments have prevented individuals convicted of murder or the indecent or sexual assault of children from appealing a decision to the New South Wales Civil and Administrative Tribunal. Now, while the loophole allowing child murderers to appeal a decision that bars them from a working with children check clearance has been closed, the Minister has indicated his opposition to preventing child murderers from caring for children in the future, whereas other states, such as South Australia, have enacted such legislation. The Shadow Minister in the other place in debate on this legislation foreshadowed that the opposition would propose a series of common sense amendments to this bill, which were in fact proposed, unfortunately voted down in the other place. Those amendments were drafted to ensure the safety of children and young persons in school grounds. I'll return to those concerns shortly. We indicate, for the benefit of members in this House, that the government will be given another opportunity to embrace these common sense amendments in this place, as you would expect of me. We couldn't let the Minister's truculence and short-sightedness turn against the public interest. So we will allow the government the opportunity to reflect and to repent. These amendments will enable the Children's Guardian to cancel a clearance if the holder of a clearance fails without reasonable excuse to provide further information in relation to the clearance within 3 months of the Children's Guardian requesting the information. The bill will also amend Section 24 of the Child Protection Working with Children Act to require a holder of a clearance to obtain the consent of the Children's Guardian before surrendering the clearance. The Children's Guardian may not consent to the surrender of that clearance if it is of the opinion that it is likely there is a risk to the safety of children. Schedule 1 of the bill will further amend Section 26 of the Child Protection Working with Children Act. If a person is subject to an equivalent order from another state or territory jurisdiction, then that person will not be entitled to apply for a review or an enabling order for the length of the equivalent order. The bill will amend Section 35 of the Child Protection Working with Children Act so that agencies will not be required to report on serious physical assault or sexual misconduct matters pre-1995 unless required by the Children's Guardian. This is due to a transitional regulation to the same effect which expires on the 29th of October this year. In fact, only a few days away, Mr Deputy President. The insertion of Section 45 capital A into the Act will make it an offence for an individual to knowingly provide false or misleading information to the Office of the Children's Guardian whilst applying for a clearance, and this offence will be punishable by a maximum of 5 penalty units. Turning to Schedule 2 of the bill that amends the Children and Young Persons Care and Protection Act 1998, the proposed amendments to that Act will enable the Children's Guardian to enter and inspect any premises other than a dwelling that the Children's Guardian reasonably suspects is a place at which a person is employing a child in contravention of Chapter 13 of the Act. The Children's Guardian will also have the power to compel an individual to provide information relating to the suspected employment of children. Schedules 3 and 4 of the bill will amend the Teaching Service Act 1980 and the Education, School, Administrative and Support Staff Act 1987. For the purposes of these Acts, it is proposed that a person whose clearance is cancelled pending determination of proceedings against the person, known as a charged person in this bill, is not an unauthorised person until a conviction has been laid against the person as per Schedule 2 of the Child Protection Working with Children Act. This bill provides for a charged person to be suspended or to be given other non-child related work until a decision is made. It is the opposition's understanding that a charged person who is either suspended or dismissed immediately rather than given alternative duties may end up, of course, not being convicted. There are examples of charges having been withdrawn by police. If they have been dismissed, they will be unable to continue in their previous employment. And we understand that as the reason for this amendment. While it may be more reasonable for the charged person to be given alternative duties than to be dismissed or suspended, we must ensure they're not put in a position where they could, which I emphasise that, Mr Deputy President, could pose a risk to the ongoing safety of school children, which is why the opposition amendments should be supported. It should be clear that if a member of staff, either under the Teaching Service Act or the Education Act, were to be charged, they should not be allowed to perform duties on a school site. The bill requires amendment to reflect this common sense approach. The bill provides that a charged person or teacher, as defined in the legislation, can pose a risk to children if we do not clarify that they cannot remain on a school site when they are given alternative duties. In these circumstances, a charged teacher could continue marking, for example, while working from home rather than in a school office while children are at the school. A charged person might be transferred to the department or they might work from home. The opposition will move amendments to address this point. In the second reading speech, the government stated the bill supports the commitment of the government to keep children and young people safe on an ongoing basis. The opposition, of course, supports that approach and will hold the government to account in that regard. In his speech, the Minister stated that the amendments made in 2015 provided for the establishment of an expert advisory panel that would provide general advice to the Children's Guardian and in particular to the New South Wales Civil and Administrative Tribunal when it considers matters on appeal. The panel was to include forensic psychologists, psychiatrists and mental health and other specialists who would provide guidance to the Children's Guardian and to the Tribunal. The understanding of the opposition is that the panel is not presently functioning. It has received 10 applications but only 3 have been approved. The panel was announced in September 2015 and the government has failed to ensure it's up and running, which is, if correct, a matter of significant incompetence, and would ask the government to address that matter in its reply in this place. The government should explain, the Minister ought to have explained already, why it has taken more than a year to set up a panel of experts to advise on who should or shouldn't be able to work with children. When the welfare of children is at stake, delays such as this are not acceptable, Mr Deputy President. When it comes to the safety and welfare of children, we can't afford to let any inappropriate individuals slip through the cracks. We must make sure that the regulatory regime, as proposed by Parliament, is fully operative. So we ask the government to support the amendments that the opposition proposed in the other place and will again propose in this place to ensure that persons who are charged are not working on school grounds while waiting for a determination on their charge. So with those comments, we of course do not oppose the legislation and we look forward to the committee stage of the bill.